For those who have been seeking to exercise their fundamental human rights and freedoms, but have been having trouble within the justice systems, whether of their province or of Canada itself, this video is for you. I hope you enjoy, and I hope this puts to rest what needs to be put to rest. Below is a citation from the majority decision in R versus Hape, SCC, affirming that prohibitive rules of international law are to guide the interpretation of Canada's law and development of the common law. In my view, following the common law tradition, it appears that the doctrine of adaptation operates in Canada, such that prohibitive rules of customary international law should be incorporated into domestic law, in the absence of conflicting legislation. The automatic incorporation of such rules is justified on the basis that international custom, as the law of nations, is also the law of Canada, unless, in a valid exercise of its sovereignty, Canada declares that its law is to the contrary. Parliamentary sovereignty dictates that a legislator may violate international law, but that it must do so expressively. Absent an expression derogation, the courts may look to prohibitive rules of customary international law to aid in the interpretation of Canadian law and the development of common law. Paragraph 53 of that judgment. It is a well-established principle of statutory interpretation that legislation will be presumed to conform to international law. The presumption of conformity is based on the rule of judicial policy that, as a matter of law, courts will strive to avoid constructions of domestic law pursuant to which the state would be in violation of its international obligations, unless the wording of the statute clearly compels that result. R versus Sullivan, Sullivan and Dredger on the construction of statutes, at page 422, explains that the presumption has two aspects. First, the legislator is presumed to act in compliance with Canada's obligations as a signatory of international treaties and as a member of the international community. In deciding between possible interpretations, courts will avoid a construction that would place Canada in breach of those obligations. The second aspect is that the legislator is presumed to comply with the values and principles of customary and conventional international law. Those values and principles form part of the context in which statutes are enacted. Courts will therefore prepare a construction that reflects them. The presumption is rebuttal. However, parliamentary sovereignty requires courts to give effect to a statute that demonstrates an unequivocal legislative intent to default on an international obligation.